So friends, Judge Tanya Chutkan gets Donald Trump's D.C. criminal case back from the Supreme Court, and within 24 hours, she denies not just one, but two of Donald Trump's motions to dismiss his case. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, I've said it before and I'm going to say it again, Judge Tanya Chutkan don't play. Now that she finally has Donald Trump's D.C. criminal case, the one for trying to overturn the results of the 2020 presidential election, which he lost, now that she has his case back in her capable hands, she is full speed ahead. Let's start with the new reporting. This from ABC News. Headline, Judge denies Trump's efforts to dismiss D.C. case over selective prosecution claim. And that article begins, in her second move since resuming control over Donald Trump's federal election interference case, Judge Tanya Chutkan denied the former president's motion to dismiss the case based on selective and vindictive prosecution. Chutkan found no evidence that prosecutors abused their authority or behaved vindictively when bringing their case against the former president. In denying Trump's motion, Chutkan criticized what she called Trump's improper framing, that the allegations against him are a theory that it is illegal to dispute the outcome of an election and work with others to propose alternate electors. Quote from Judge Chutkan, at this stage, the court cannot accept defendant's alternate narrative, Judge Chutkan wrote. Before the federal case was frozen for more than half a year by the Supreme Court, defense attorneys attempted to have the case thrown out by arguing that Trump was selectively prosecuted and unfairly targeted to prevent him from becoming the next president again. This quote from Judge Chutkan, after reviewing defendant Trump's evidence and arguments, the court cannot conclude that he has carried his burden to establish either actual vindictiveness or the presumption of it, and so finds no basis for dismissing this case on those grounds, Chutkan wrote in a 16-page order. Chutkan found that Trump failed to provide evidence for either prong of the two-part test to prove selective prosecution, that he was singled out for prosecution, or that the case was motivated by a discriminatory purpose. Quote, finding no evidence of discriminatory purpose, in the sources defendant cites, the court is left only with Trump's, unsupported assertions that this prosecution must be politically motivated because it coexists with his campaign for the presidency, Chutkan wrote. So friends, I want to use that last sentence as a springboard to jump into just one thing Judge Chutkan said in her 16-page ruling, the sentence that reads, finding no evidence of discriminatory purpose in the sources Trump cites, the court is left only with Trump's unsupported assertions that this prosecution must be politically motivated. And I'm going to circle back to that sentence in a minute, but first, let's talk about selective prosecution. It is actually a thing. There's a doctrine in the criminal law called selective prosecution. If the defendant can prove he is being selectively prosecuted, well, then maybe he can convince a judge to dismiss his case. So what is selective prosecution? This is going to be a quick Team Justice Law School class. So Donald Trump would have to prove that similarly situated defendants, similar to him, who committed similar crimes like the ones he committed, were never prosecuted. Only he was prosecuted selectively, improperly, unfairly. So in other words, all of the other presidents of the United States who lost presidential elections and who then went about criminally attempting to retain the power of the presidency by, among other things, ordering his supporters to attack the Capitol to stop the certification of his loss and ginning up fake electors and all of the other criminal acts Donald Trump engaged in. All of the other presidents of the United States who did that same thing were never prosecuted. So it's just not fair. It's selective. He shouldn't be prosecuted for those same crimes that other presidents committed. Because, friends, think back through American history. Every 4 years, what do we have? A president committing crimes, unlawfully trying to retain the power of the presidency, coming up with fake electors, ordering his angry mob to attack the Capitol to stop the certification of his election loss. When you look back through all of time, American history, every 4 years, there's never been a peaceful transfer of power. The same thing that Donald Trump did happens every 4 years, and none of the other presidents are prosecuted for it. Only he's being selectively prosecuted. Friends, that's what Donald Trump is claiming. And that argument collapses under the weight of its own frivolity, its own foolishness. But that is what Donald Trump is claiming and what he has to prove. He has to have actual evidence of it if he is to have his case dismissed based on unlawful selective prosecution. But as I say, selective prosecution is a thing, and it requires a defendant to prove two things. It's a two-part test, and the defendant has to prove both things, and here's what he has to prove. To succeed on his selective prosecution claim, defendant Trump must satisfy a two-part test. First, he must demonstrate that the federal prosecutorial policy had a discriminatory effect in that he was singled out for prosecution from among others similarly situated. And second, defendant Trump must show that the prosecution was motivated by a discriminatory purpose. And friends, Judge Chutkan went on to rule that Donald Trump failed miserably to prove even one part of the two-part test, and he needed to prove both parts if he had the hope of winning any relief. This is priceless. Regarding discriminatory purpose, defendant Trump posits that the government's prosecution is driven by an unconstitutional discriminatory purpose, and in support of his argument, Trump submits two newspaper articles, one from the Post and the other from the Times. Friends, newspaper articles aren't evidence. You know, I never did try a case and in my opening statement say, well, ladies and gentlemen, I'm just going to give you some newspaper articles to read and ask you to find the defendant guilty. But believe it or not, it gets worse and even more laughable. The newspaper articles defendant Trump submitted do not establish that his prosecution was improperly motivated. In the first place, Trump misreads the articles. So friends, even news articles, news clippings, that Donald Trump tries to use as evidence in a court of law, even those don't say what he claims they say. Why? Because, quote, he misreads the articles. You know, friends, you can't make this shit up. But that's what Donald Trump does. All day, every day, he makes shit up. And I apologize for the language, but in the court of public opinion, every day, all Donald Trump does is lie. He lies. He lies. He makes shit up. Well, you know what? You can get away with it in the court of public opinion, but you can't get away with it in a court of law. And Judge Chutkan will make sure of that. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.